Cybersecurity issues are becoming more prevalent in M&A deals these days. The two major risks facing buyers primarily are relating to cybersecurity include the seller may or may not have been the victim of a cyber attack, and secondly, the seller may or may not be in compliance with significant privacy and cybersecurity laws. During due diligence, buyers should do a few things. Primarily, the buyers should identify the seller's high-value digital assets. And if there are some of those high-value digital assets, buyers should consider retaining a cybersecurity expert to assist in the due diligence. Other things that buyers should do is they should identify the internal cybersecurity program used to protect those assets. They should also evaluate the seller's cyber risk management efforts as they relate to third parties into which the seller depends for various services. Buyers should also consider reviewing seller's prior breaches and evaluate its responses to those breaches. They should also review the status of the seller's cybersecurity regulatory compliance. And finally, buyers should evaluate the seller's overall ability to withstand a direct cyber attack on its digital assets. Following due diligence, there are some specific things that buyers can do regarding definitive agreements. Buyers can use the results of the due diligence to obtain contractual protections or even risk allocations to the extent of even a price reduction for privacy and cybersecurity issues. For example, buyers can require interim operating covenants requiring corrective actions. They can require specific indemnities from known or unknown security vulnerabilities. And they can also require well-drafted representations and indemnities to address hidden or undisclosed issues that may arise after closing. Regarding post-closing issues and considering the regulatory environment we're in these days, regulators are now becoming more aggressive as it relates to cyber attacks and privacy violations. So to the extent that the IT system and the data protection practices of the seller are less secure and rigorous than those of the buyers, integration could eventually expose the buyer's own data to security breach. So therefore, any issues discovered during due diligence should ideally be addressed prior to closing, or in any event before integration with the buyer's data or its systems. So as the cybersecurity landscape for M&A deal transactions will continue to become more complex, as cyber technology evolves and regulators gain more expertise, parties to M&A deals should carefully consider the potential risks and challenges at each stage of a transaction in order to plan for and effectively address them before, during, and after the signing of the definitive agreements.